Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. Now, I always enjoy reviewing these books from the Association of Personal Injury Lawyers and Jordans. These are special guides, the APIL guides as I call them, for personal injury work, which I do in conjunction with many colleagues at the bar and in practice as solicitors. The book we're looking at today is a new one. It's the APIL Guide to Noise Claims. It's been written by Chris Fry and Theo, Huckle, Queen's Counsel, and it has assistance from Joseph Wynn. It's been published by Jordan Publishing and is available as an ebook. Now, my wife and I have looked at the title, and we gave it, the book itself, the title, and we gave it for our review title the following: Noise Matters. That can be taken either way, of course. We are well supported by APIL and Jordans with this new practical exposition of how to handle noise proceedings. Before we go any further, let me show you. It's only a short book. It's a paperback, small book. There we go. Probably going to expand a little bit. Now, what you've got there is the spine, and then on the back you've got a little bit of detail about this new book. As I say, it's a very small book. It runs to just 164 pages. The index is at the back, and what you've got after the index are some various model letters in the appendices and so on. And then at the front, we've got the front page there, and then after that, we've got an important preface, which is well worth reading. In fact, I've taken for part of the review some of the quotes from the preface because of the case law and the purpose which the two authors had in actually creating this book in the first place. Because noise claims, and it's very specific noise claims we're talking about here, are an area which is changing. It's quite technical as well. There's some detail about APIL, which is always worth knowing about. And if you want to join, there's contact details there. Then you have the contents. You see it's paragraph numbering, and you've got quite a lot of detail actually in the contents themselves. There are a total of 7 chapters, and then a series of, in fact, 2 main appendices to go with it. Then table of cases, quite a lot of cases, and after that you've got some statutes, only a little bit, and a few SIs there, statutory instruments. Then you, as usual, table of EU materials, or EC materials. Interestingly, these will still remain. I know we are Brexiting, but they will still be around for some time to come. Now, there's a glossary, which again, I think, bearing in mind this is about noise, you do need a glossary because there are lots of words which you probably are not very familiar with, very scientific words, and you can see them listed there. Then we get into the overview in chapter 1 of the subject, paragraph numbered, as I say, with footnotes, so you've got a lot of stuff. Then you've got medical diagnoses, for instance, hence the fact it's PI. The book is available as an ebook. Always note that little sign there. But as I say, it's an important book. It's a technical book in some respects, but as the authors say, beware, because this is actually quite a technical subject. Now, what do we say about the book? Well, we say this: the issue of noise is often underestimated by both clients and the professional advisor when we become involved in litigation. Luckily for us, we've got this excellent new work on noise claims written by Chris Fry and Theo Huckle, Queen's Counsel. It's available, as I say, as a book and an ebook, and it's designed as a manual to help lawyers understand the core principles and identify viable cases as early as possible. And they've been most successful, we think, in their task here, because it's a new area, for many people, quite a new area of activity, professional activity. It's quite clear to us as practitioners that the collaboration between the Association of Personal Injury Lawyers, that's APIL, and Jordan Publishing has been of massive benefit to all of us advising and acting in proceedings for personal injury. These books really do bring the subject very much alive. I've certainly found that, and I think other colleagues have, in the PI world. And I'd like to thank everybody who's been involved, because it makes our lives easier in a continually more complex environment in which we work. The book's also, I think, very reader friendly and easy for a litigant in person to understand, thanks to the logical layout and the simple structure of the guide itself, with the excellent real-world case study. One of the most important areas covered in the APIL Jordan series, is the newcomer to what is called industrial deafness work, which is classified here as noise claims. I think that's important to remember, industrial deafness work, because in the past you probably would have thought, oh, this is something that would fit into another category, but it is definitely a personal injury category. The authors, I think, have succeeded brilliantly in giving us a practical commentary covering all the main issues in this field in 7 short and detailed chapters in about, let's say, 150 odd pages, plus the 2 useful appendices. The guide also includes the following, and I'm just going to quote what is actually in the book so that you know what it is you might be wanting to get a little bit of additional information on. It sets out a case study through the entire claim process, starting with the initial triage risk assessment, through claim intimidation and pre-action protocol, the collection of lay witness evidence, expert medical and acoustic engineering evidence to completion. There's also a comprehensive analysis of the regulatory framework, and the authors explain how to analyse audiograms against the Coles, Lutman and Buffin guidelines on the diagnosis of noise-induced hearing loss. That's NIHL, which features, of course, quite heavily in the guide. And obviously it's very useful for medico-legal purposes, which we thought was actually probably one of the most substantial areas for the guidance which we might be seeking. Guidance, of course, is also given on how to work out noise emission levels, saving substantial time and expense in utilising experts and improving risk management itself, which of course one has to bear in mind in these types of litigation. There are several precedents, including a letter of claim, pre-action disclosure applications and pleadings, including which we found of great assistance, I think, for anybody involved in professional advice. And of course lay people will also find the various precedents set out here to be of great help. Fry and Huckle say that they started out in noise work and they were armed really with little more than the pre-action protocols themselves and a blind faith that the medical expert opinion confirming NIHL, remember what that is, that's the noise-induced hearing loss, in other words the negligence bit, if I can put it that way, the NIHL, was, and the quote is, quote, likely to be scientifically accurate and reliable. Just so, in our view, but beware the complexities which are illustrated throughout the guide. And in fact they do give some good words of warning throughout. And they comment, for instance, that for years the battleground in litigation was primarily over whether a claim had been brought in time, and occasionally whether noise levels were high enough to show that the defendant was in breach of duty. And again, remember the basic principles of negligence. Their conclusion was that diagnosis was rarely at issue. Well, I mean, I think probably that is the case, but I don't know, sometimes judges will take issue, of course, as well. Let me conclude by saying that the authors comment that the case law is again rapidly evolving. They made that comment right at the beginning in the preface. And they say with many bright young lawyers pursuing new approaches, so we think there'll be a new edition in the foreseeable future. And they go on to say that the young bar will be delighted to know that the new edition may well come in quicker than they think, because this is actually probably a bit of a growing area of law to many younger advocates. The authors also stress that it's most important not to underestimate the complications and numerous risks at each stage of the NIHL case, which is why this new title, I think, is worth so much. It's worth its weight in gold, in my view, to those pursuing new approaches to noise claims. I would say they are technical, and you have to have some understanding of what these issues are about, but it's not that difficult, and I think this book makes it a great deal easier. The publication date is cited at March 2016. It came out about that time, and I'm reviewing it at the middle of the year. there's the actual book again. There's the spine, and then there's the back cover. Just opening it in the middle. Limitation, action, times, background, chapter 3. You've got paragraph numbering again, and as I say, you've got a little bit of footnoting, but not a lot. For instance, there's some footnoting there. It's just really to justify some of the points, in case you're asked, although, in fact, as has been said, quite a lot of this area will not be the subject of specific main collision, if I can put it that way, in terms of forensic argument. These are the appendices, and you can see the model letters there, which are very helpful, setting out the various points concerned. Model letters, pleadings and applications, and so on. And then, of course, the other one that you've got is the Appendix 1, which is on a template, noise-induced hearing loss questionnaire. And again, like everything else, these questionnaires are very important because they do form part of the evidence. Thank you very much to Chris High and Theo Huckle QC, also to APIL and Jordan's for another very, very helpful guide in the series. Thank you. We really do rely, as I've said before, on this facility and this service you give us, so thank you. Bye-bye.